you for joining us for the fourth class of the County Mental Health Law Plan on Competency Restoration. Today, we have a special guest, Elise Ferguson. She is currently serving in a new venture as the President of Operations for AKA Homes. She's the former Chief Attorney of the Collin County Mental Health Managed Counsel Program. You are all probably familiar with Elise. She is the one who has the great ideas. She has worked in the field, figured out what wasn't working, and come up with really practical, tangible solutions for the day-to-day practice and improving at least our side on the judicial side of competency restoration. Everyone, welcome Elise. And what we are planning today is to, again, walk through some slides that have the information we want to share, but we want this to be an open format and for you to be able to ask questions in the chat, raise your hand. And I really am serving as the policy expert on where we need to go as a state on competency restoration. And Elise is our legal expert who has done this many, many times and has a lot of experience in the intricacies of doing those court-ordered medications and some of those really complicated processes. So don't be shy about asking your hard questions, and we'll go ahead and get started. Okay, so the iceberg that we see is the 2-year wait list on the inpatient state hospital competency restoration. What we sometimes don't think about below the iceberg are the years and years of causes for this. Now, I think we're at 1,900 people on the wait list. We have a lot of inefficiencies on everyone's part. We want to make sure as the legal system that we are not becoming a burden to this process. We want to be creating processes in our own house that keep things going and that just make sense. One thing that we know that is happening across our state, across the country, is a belief that competency restoration is a comprehensive treatment program. I am reminded that this is not the case. If you want to go back and look on our website, we have a video from the 2021 summit where our commissioner, Adrienne Kennedy, talked about her family experience. She talks about how her son got sicker and sicker in competency restoration, how the medication that he was given was really to calm him down and to sedate him so that he could learn those legal concepts more easily, and that he became more psychotic. And she tells a heartbreaking story. She did eventually lose her son to mental illness, but she was overjoyed by the efforts that we're making in this state to think about what competency restoration really is. It's a legal concept. Yes, there's some treatment given, and I'm sure it varies by which facility you're in, but in a lot of people with lived experience, in a lot of their cases, it wasn't that comprehensive treatment that we're hoping that it might be. And so we have to think about, who are we incarcerating? If it's somebody with a serious offense and they need to be incarcerated, they will be incarcerated. But what we have seen are people who are not dangerous and are stacking up public intoxication or just trespassing. And I know sometimes that can be serious, but we all know the ones that that are harmless and that aren't dangerous, and they're just stacking up those charges that could even become a felony because their mental illness is going untreated. So we want to think about those individuals that maybe if we could have connected them to services and started some new diversion programs, maybe they wouldn't even be on our competency restoration list. And if you go all the way back through the history, some people argue that this began with the deinstitutionalization in the 60s and 70s, and that we were hoping that the communities would really be resourced to pick up that service and have a place for people who were no longer institutionalized. And what we saw is that the funding did not really connect to the communities to be able to support that. a lot of you have been in this business for a while know that we had gotten to a high of, I think, 25 or 2,600 during COVID. So we are back down to 1,900 on the wait list, but that's too long. It's still a 2-year or so wait. And it's really breaking the entire system. If we are encouraging you all to use civil commitment rather than putting people into jail, we have to be able to have the bed space for the civil commitments. And right now, our forensic patients are taking over that bed space. And we have seen a sharp incline, as you all know, in this in Texas. Big picture, a couple of things I would like to start off with is that we want to refer you back to that checklist that we've created. It has some big picture themes. Divert when possible. And I know a lot of people say divert to what? So that's why we have the when possible. But we have seen a lot of rural communities get very creative, use mental health officers to go out and check on people and let them be out on bond, using their MCOT team. Some of those suggestions that we talked about in the first few classes, this is when all of these pieces come together. That if you think about diverting people and then they never make it to the wait list. We also want to encourage using specialty courts. If you're a county with a population of over 200,000, you are required by law to have a specialty court, actually to have a mental health court. And as far as we can tell, it needs to be an adult mental health court. And we have a lot of resources that could help build that for you and mentors within our commission and our network that would love to help you start one of those. And it sounds pretty intimidating, but we talked about this last week. It could just be a docket. It can be a very small start. We want to reserve competency restoration for inpatient individuals when there is a strong interest of the state to prosecute. What we know is that misdemeanants are going to time out. And so we really have to think about putting misdemeanants on the inpatient list if they're going to time out, and then we're just going to release them and they're going to be worse off than when they started. So think about who we are putting on that list and to consider alternatives to state hospital. If there are outpatient competency restoration programs, jail-based, if you have interest in building those programs, what can we do? And then the last, we really leaned on Elise for this. She has been the creator of so many efficient court processes that you can use within your county to just shave those bed days, even by a few. When you think about everybody that comes through your jail or everybody that's going through state hospital, that really makes a big difference. Okay, Elise, anything that you want to jump in on right there?
Really just that, and I think we can talk about efficiencies, and you'll see them in the notes that the Judicial Commission has, but the efficiencies are really about how to maximize the use of the jail bed days that are going wasted. And an example of that is when the state hospital emails your county and tells you, or actually sends snail mail to your county and tells you that your person's ready to come back, the time from that letter to the time you pick them up is wasted bed days that somebody could be using. So by maximizing efficiencies such as getting the state hospital to email versus snail mail, and by picking them up sooner rather than later, we can utilize those bed days for other patients. So there are a lot of efficiencies we can put into play.
Yes, we'll get more into that later. Thank you. Okay, so from some of those efficiencies and other ideas, before there was the County Mental Health Law Plan, JCMH started the Eliminate the Wait with HHSC. And this is a checklist that really focuses on competency restoration. But of course, you can't really talk about competency restoration without talking about diversion to prevent us from getting there. But some of the big picture ideas from Eliminate the Wait, again, are to consider those options in lieu of the inpatient competency restoration if possible, to do active waitlist monitoring. This is when even the smallest county can form a collaboration to get together with the jail, with the mental health providers, and prosecutors, defense attorneys, sit down and look at who is on your list. And again, that's something that Elise can tell us more about later, that she practiced for many years. those efficient court policies, making those small changes, like having a point of contact person that's going to be responsible in every agency to think about how you're doing mental health. And that education and awareness. We can't emphasize this enough, that we have to be talking about what's happening and why our laws are really breaking the system right now. So the goals of Eliminate the Wait are to look at diversion when possible, to counteract that belief that competency restoration is treatment, and to really bring home that it's more stabilization and sometimes just rote memorization of legal procedures. I don't know if any of y'all have seen the curriculum they use for competency restoration, but sometimes it's in a game show format. And it really is just drilling in who the legal participants are. And so that defendants can answer those basic questions and get over the hurdle of being incompetent. So why are we talking about all this? Well, criminal competency and incompetency is a very important concept. These are constitutional protections. The Dusky standard, and then codified in our chapter 46B, is, starts off with a great purpose, that we want defendants to have the ability to talk with their attorney and be able to have meaningful input into their defense, and also for them to have a rational understanding of the charges against them and to be able to help with those proceedings. So it, starts off with a very noble purpose, and it's, since been codified in 46B. And what we have found out, that there is almost a train, that when you get on the train of noting that someone might be incompetent, that the court must stay that criminal proceeding, and that it's very easy to keep going into inpatient competency restoration, even if that's really not the most appropriate solution. So if you're looking at the process, we start off with a criminal charge. And I know all of you have probably done this before, but we do have some partners that are from our civil commitment side. And so I want to make sure and cover the basics, that if the competency issue is raised by any party, or it could be court suggestion, or it could be an informal inquiry by the court, then you move on to the examination of the defendant. And then the competency evaluation will reveal if the recommendation, what the recommendations are for this individual. And then the court will ultimately determine competent to stand trial, incompetent to stand trial, restorable in the foreseeable future, incompetent to stand trial, not restorable in the foreseeable future. And there is some interesting history behind this that really helps me understand and have compassion for how we got in this situation. We have a commissioner, Professor Shannon, who talks about how he worked on changing the law in 2003 because the competency restoration law was too strict. And it was such a high bar that very few people were getting the evaluations that they needed. And so he said at that time, they could have never imagined that we would have 1,900 people on the waiting list. So the language was specifically set to be expanded to expand that scope of situations, and to really urge the courts to consider when people needed competency evaluations. But again, this is sort of the graphic of that train that we talked about. And it's interesting because our partners at HHSC that are in the mental health space had come to us and said, why are so many judges ordering people on this list? Why are we putting misdemeanants on the list? Why are we putting everyone on this list? And they didn't really understand it from a clinical point of view, that it's not going to be the best thing for that person. But from our perspective, when we go back and look at the law, there's a path that you get on that there's not a lot of wiggle room. So the point of this graphic is to show that in the courtroom, you even have that suggestion of incompetency can set you on that path that really is set for inpatient competency restoration. There are some directives to look at outpatient and jail-based, but I think a lot of people see this and just get the evaluation, and then they're on the list, and they, a lot of judges feel like their hands are tied. So one thing that we want to encourage is looking at, is this a case with that strong interest in prosecuting? I've even heard, defense attorneys and judges say that until we have that law changed, it's almost a game of nobody say it. If we think there's a better solution for someone, say a misdemeanor, it's not dangerous, we could connect them with the LMHA, they could be out on bond, they could maybe receive services that way, have that mental health officer follow up. If there are other solutions that you can think about, then try not to go down that incompetency path. So this is an excerpt from our county mental health law plan checklist. And we are hoping that in your counties, you are working on this, going through these questions and asking yourselves, do our judges know about this statewide policy problem? Do they know we're working to change the law? Are we educating on all the other options that may be available? To help you understand what might be coming in the future, this is a actual proposal that JCMH worked with the Texas Judicial Council to try to get this law changed in the last session. It was not successful. So I think the Judicial Council will be looking at this and deciding if they want to pursue it again. But basically, this would be a default that when someone is found incompetent to stand trial with a Class B and it's nonviolent, that the default would be to go to outpatient competency restoration. And I know some of you are saying we don't have outpatient competency restoration. So we added a part to that to say if there is no OCR available, either because the community doesn't have it or the defendant isn't a good fit for that program, then there would be another option to consider of looking at civil commitment. So that is the option. I spoke with someone from Illinois yesterday. They did pass this because other states are having the same problem. There are more extreme versions. I believe New York has passed something that says no misdemeanors can be on the wait list ever, period. We didn't think that was really going to fit Texas. And so this seems to be the more moderate version of that same idea of let's save the inpatient wait list for those that we know they're going to reach their trial date. One thing to think about is to use different strategies for different people. And we want to make this clear that we're not asking anyone to let out people who are dangerous, but to just take a critical look and use your discernment to think about who really needs to be in a locked facility and what is the least restrictive appropriate setting. If we could start looking at categorizing people and thinking about there might be some that initially need to be in a locked facility, but then we are able to get them the medication they need through court-ordered medication, or maybe they'll take it voluntarily and we get them stabilized. And then we need to go back and take that look and see if they still need to be on the wait list. And then we want to recognize that there may be some people who, even though they're very seriously mentally ill, it was a serious offense and they will be locked up through their case. This is a slide that I borrowed. There are a few in here from Professor Shannon when he's teaching on this. So it's just an important point that I think we need to do more work on at the commission, that to recognize that the court has a duty to determine if the examiner is qualified and to be more familiar with those training requirements and to realize it cannot be the treating doctor. And one thing that may not be well known, the form that is actually promulgated by Takumi is not up to date. So we're working with them to get that up to date. But that on that form, we really need to make sure that it says the person performing the competency evaluation knows that they need to state the symptoms, the exact nature, the severity. Really important to state the expected duration of the mental illness. How is the judge supposed to make that determination if they don't get good information from the doctor about the estimate of period needed to restore the defendant's competency and whether they're likely to be restored? we also hope that that evaluation will include prospective treatment options. Elise, is this something on your competency evaluations that you've seen has been a problem?
No, we don't really have much problem with that in our area. Most of the experts have a standardized form that makes sure they cover that. Sometimes there's a doctor that's new to the area and may miss it, and we just go back to them and let them know, hey, this is missing, and they're usually great about updating it and putting the necessary information. But I do feel that a standardized form would be fantastic.
Yes, and Elise actually is someone who works on our legislative committee to help tweak the law to make it work better on things like this, because this was a statute that passed a while ago to make sure that the competency evaluation form included this. And so it will be good to get the form updated and make sure that all of our evaluations are reflecting that. Okay, so more questions to ask your county when you do your self-analysis. Does my county educate my partners that it's not comprehensive treatment? Do we have a policy regarding misdemeanor cases? Are we really talking about that? Are we considering the treatment and diversion alternatives first and using competency restoration as a last resort?
And Christy, if I could chime in on that, I think you probably have you probably have a diverse group on here, prosecutors, judges, defense, but what I've often found is what you mentioned earlier, that the state wants the person to get treatment and doesn't recognize that this is not treatment. And so I think that's the first question I usually ask if I'm called by a prosecutor, and to say, what can we do? It's okay, what do you want to accomplish? Is your goal to just get them competent so you can have a conviction, or is your goal to get them treatment? Because those are two very different things, and it might help you to better direct how you can resolve that case.
That's a great question. Maybe we should add that to the checklist, is what is your goal, as a way to capture that question. So another resource we wanted to highlight is the HHSC Competency Restoration Guide. They released this, let's see, not that long ago. I think it was at our summit is when we first saw it. So October of 23. And this is just some of the things that that work group developed, is a decision tree on what would be clinically and legally the most appropriate form of competency restoration for that defendant. Okay, and then if we decide that competency restoration is necessary, have we thought about outpatient competency and jail-based competency? And is there, if we don't have it in our county, is there a nearby one that we could make a regional program with? Sometimes I know I've heard of a diversion program in one urban county right now that is not being used enough. And they actually are really trying to seek other counties to come use it so that they can, keep the doors open and justify its existence. So you never know, it might be worth a conversation. In Collin County, you had both outpatient and jail-based, right, Elise?
No, we did not have jail-based.
Okay. And outpatient, did it work well? How did you find it?
Outpatient did not work well for us because I think the majority of the people who were incompetent on the lower level offenses were homeless, and we don't have a homeless shelter, so to speak. And so when a person is worried about where they're going to live, it's really hard to get them to participate in services.
Great. So that might be something to add, that if you're thinking about outpatient competency restoration, is look at housing, see what your housing resources are. So you'll see that in the 46B statute, it is a mandate that if the court determines that a defendant's not a danger, that they may be safely treated on an outpatient basis, and that an appropriate OCR program exists and is available, that they should go ahead and use this. So I think the availability is a problem. I would love to hear in the chat if any of the counties on here have it. I know Travis does, and I'm not sure about El Paso, but there are grants that are available through HHSC that can help you start one of these programs. I know that the jail-based programs especially have sometimes been started with very few resources. I toured the one in Lubbock, and it was really just a room in the jail that they set aside for a learning space that, it had like a whiteboard and some learning materials. They also had the luxury of separating out their defendants with mental illness or IDD. And so that they could be in, it's still jail, but a little bit more of a therapeutic space than just in the regular population. But the jail-based competency restoration program itself was not that difficult to set up from what I've heard. It can be controversial. There's some people that definitely will argue jail is not the best place to have your competency restored. But we are in a realistic view of the alternative is sitting in jail and for up to 2 years. So I think you have to weigh that. The benefits, if you can get your outpatient competency restoration program up and running, it can cost less, potential for shorter stays, and it frees up those precious bed days that we're talking about. Okay, so this is one of those best practices that we talk about that Elise was very involved in, is monitoring the wait list. And that sounds really simple, but just having, I think in Collin County had maybe weekly meetings, and other counties have had, every other week, but just getting those participants together to talk about everyone on the list and are we doing everything we can? And we're going to talk about medication a little bit later in the presentation. But if medication is a possibility and they, they call it spontaneously restore, are we acting quickly enough to get that person off the wait list and get them connected to services? So, Elise, will you share what a typical meeting looked like when you were monitoring the wait list?
So every week we would meet with both the jail and our medical team, as well as our LMHA, to quickly review each of the cases that was on the wait list, and even cases that we thought might be incompetent, but perhaps were taking medication and could wait a couple weeks because they might not be incompetent. They may restore to baseline with the medication, but we'd review each one of those to see what their status was. And if the doctors felt it was time for a reevaluation, just quickly, and I mean, 2 minutes a piece maybe is all it took to go through those to just see, was there something else we could be doing and how we could move that case and communicate with the courts. If someone came back from the state hospital and we felt that they were deteriorating, we would email the courts and all the parties and say, okay, you're not going to have much time. This person's starting to decompensate or whatever it is. It's really just about communicating and making sure everybody's up to speed.
It sounds simple, but very effective. I'm sure you had examples of people that were able to move off the list and more importantly, not just off the list, but to actually be better and to have a better chance at being well.
Absolutely. And that's where the medication administration comes into effect a lot, I believe.
Okay, let's move on and we'll get to that. Okay, so these are some of these efficient court policies that we talked about. Elise started the point of contact, and again, so simple, but why aren't we using email? Why are we using snail mail? If you think about, she did the math once, if you think about every single person coming back from state hospital, waiting 7 or 5 days for it to go through snail mail, how much money we are wasting with that. So some of the practices Elise suggested on here is sending an annual letter to state hospital, notifying them, this is our contact person. This is their information. Who's your contact person? Who do you want us to talk to? And also, have a relationship with your local mental health authority so that if you are having a hard time getting in touch with the state hospital, that they can be that conduit for you.
And the easy way to do this, we found, was when the jail sends your packet to the state hospital, we just had a red cover sheet on that packet that says all court communication is to be done in this manner, through this person, through this email. And quite frankly, the state hospitals love it because it's a burden on them to try to track things down through multiple people in the courts, and they love having that point of contact. So they appreciate that as much as we do, and it is a huge time saver.
Love that. We need as many free examples or almost free examples of things that can help improve the wait list that we can get. Okay, so some more of these efficient policies. Does my court coordinate with the probate court? So when we get into the medication proceedings and we talk about the Texas two-step of why the criminal courts and the probate courts need to have a line of communication, do you have a process so that your medication orders will start immediately while the person's awaiting the transport? This is under the check mark. We have if the person stabilizes, have I ordered a reeval or check for evidence of immediate restoration? So that's a really important one. How many times have we seen somebody come back from the hospital and sit and deteriorate? Or, you know, in this case, that they have stabilized and maybe in jail, and we haven't quickly enough reevaluated them, and then maybe we start the whole process over again. So are we scheduling status conferences while the person is at state hospital? I feel like this is so important. This is from Elise again. Do I urge the defense attorney and prosecutor to keep working on the case while the person is at state hospital? Like, no, they are not a black hole. Do not put that file away and not look at it again. Are you continually looking ahead and being proactive and making sure that these conferences are being set up and that hearings are being set up as soon as you can possibly work that?
And let me toss this out to the judges and attorneys that are attending today. You know, a lot of times we sit and we, as you said, don't work the case until the person comes back, but we generally know which cases are going to go to trial and which ones may be a plea. And because of the court dockets being backlogged sometimes, it's okay to go ahead and hold that spot and just keep bumping it 3 months so that there is a spot on the docket for that trial if needed when they return. And the other piece is very often we wait to begin anything on an insanity defense because insanity says they must be competent. They must be competent for a finding of insanity, but the doctor can start that. And if you look at the volume of records and discovery the doctors need to review, it's great to have them working on that while the person's hospitalized, because then when the person returns, it leaves only a minimal amount of new records and interview with that person for the doctor to proceed, rather than taking 6 months after they return and then the person's med order expires and they've deteriorated. So always even keep working on the insanity during that period.
That's such an important point. Do we have any questions on that? She just gave us a lot of good information. Okay, we'll keep going through these efficient policies. Coordinating bench warrants and the transport of people. We really shouldn't have people deteriorating because we haven't coordinated their transport, right? That should be something that our mental health contact person can work on. Setting up the cases quickly upon return. Setting up the cases preferentially. I have a slide in here somewhere that shows the part of the CCP that says these cases are to be prioritized. The only kind of cases that are higher are ones involving 14 and under, children 14 and under. So criminal cases that have someone with competency restoration returning from state hospital really should be bumped up to the top. And I know I've talked to judges who say, I'm still backlogged from COVID. Well, I'm not sure we're doing that. I think it's taking a long time to get to those cases. So I would emphasize this one. Is this something that you were able to work with your judges, Elise, and get into the habit of putting these cases at the top of the docket?
Yes, and again, it all boils back to point of contact and communication, because if those judges know when these people are coming back and you're communicating, mine would quickly get them set on the docket and even established a policy that a case could not be passed that was a competency case without appearing before the court. Because most counties have the procedure of the attorneys handle the passes and the settings out in the hallway and not before the judge. So by requiring these to go before the court, it prevents them from just getting passed repetitively.
I love that. And that's something that you were inside, you were then managed.
Managed counsel.
And you were able to have that relationship and create some new policies. So a lot of effort went into that, but I know it was.
And that's where the counties struggle, Christy. Counties who use a wheel system for their attorneys Most of them don't have a manager, so to speak, for the wheel. And so it's left to each attorney to figure out the process, which is again where this one point of contact helps to pull all that together.
So even if you don't have managed assigned counsel, you could have a point of contact. And
oh, absolutely.
Yeah, also let's put in a plug for getting a managed assigned counsel. That's the hybrid where you still have a wheel, but you have a manager, and Elise was that manager. And then there also is the model where you can bring in public defenders, mental health public defenders even. So I know that the Texas Indigent Defense Commission gives funds, seed funds to start these. And there have been years where they have extra funds and they don't have enough people, willing to take them up on it. So we'll try to keep y'all informed of those opportunities. Is that how y'all started, with some TIDC funding?
We did. And, I think the other benefit to the counties is it provided some specialized training for mental health. Ours was a mental health managed counsel. And I can tell you statistically, when a person on that wheel, because of their training, asked for a comp eval, there was an 85% accuracy rate. If they believed them to be incompetent, 85% of them were incompetent. Whereas your regular wheel attorneys without training were about a 50 shot.
That's a big improvement. That's something else maybe for another day to talk about, is just really raising the bar on the attorneys who take these cases, both, on the defense side and the prosecutor side, for DAs to support their prosecutors to develop specialization and recognize how important this is, that to have, even if it's small, some sort of mental health unit. And then the same, I've heard some counties are paying, even if it's just a little bit more, but they are paying an increased rate for attorneys who establish that they have some expertise in mental health. That's a great statistic to emphasize that point. Okay, so one of our staff attorneys, Kama Harris, did this chart. Love her charts because this is really complicated, and I hope that when you guys get this PowerPoint, then you can save this to try to know those timeframes, and it'll help you predict when you need to be in action and when you need to be proactive about your person coming back. Okay, so more efficiency suggestions. Have a system for tracking the days. We're so careful about so many other deadlines. Are we adding these days and deadlines to our systems? Do you know the consequences and next steps if the defendant is not restored? Do you have a plan for what you're going to do next if they're not restored within the maximum time frame? And then always be aware of the possibility of timing out. More deadlines to keep in mind are when that underlying offense would have maxed out and when that person may be released. And, we got a comment in the chats about how dangerous that is to just let people time out, spit them back out in the street with no resources, no improvement, and maybe probably a worse mental health state if they weren't receiving any sort of treatment in the jail.
And Christy, this is so important because as far as I could tell, at least in Collin, nobody had the task of monitoring those timeout times. And I would find people, I recently had a case in another county where the person sat 3 months in jail because he was on the wait list past his 180 days on a Class B. So both the defense and the state need to pay attention to their time in custody, because for those people who are waitlisted, there is a mandatory dismissal requirement in there in the 46B section.
That is a great point. I found the same thing in trying to work on the county mental health law plan, that sometimes everyone is in charge, so no one is in charge, right? And the same concept of trying to create some champions and leaders within the system, because I found that there would be no one really in charge of how we're doing emergency detention, or no one in charge of how we are monitoring when what judges are hearing what cases, and making sure that we have coverage of certain things. So that's a great idea. And I'll add one plug in here for, we have funded, I guess it's been almost 3 years, a community diversion coordinator in 3 counties. And that was a pilot program. And right now it's been Grayson, Smith, and Denton. And what we would like to do is seek more funding to expand that pilot. And of course, it will depend on, how the legislature feels about that. But that is something to watch for. And the next year is an expanded pilot program And you can see how helpful that could be to have this coordinator who could be your point person and bring some of these duties together. Okay, so this is the statute I was talking about in the Code of Criminal Procedure that states that any trial where defendant has been determined to be restored to competency under 46B has priority over all criminal trials, and all criminal trials already have priority over all civil trials. So again, we are only under those trials that have victims under the age of 14. So this is probably a point that we need to bring to our courts and our court coordinators and start talking about what our policies are. Okay, so when we talked about having a plan B if the defendant is unrestored, this is the process, the subchapter E, 46B 102, you go through the civil commitment, you actually are flipped over to the health and safety code, and you go through the civil commitment process. How often did you have to do this, Elise?
Very often, this has to be done, and you do have to pay attention to the procedure on this, because the interesting thing and the difficult thing to understand is when you're talking about the first part of 46B, you're talking about, is the person competent or not competent? When you move into 102, that's not the only question. It is, are they competent or not? And are they at risk of harm or danger to self or others? So they have to meet both of those prongs in order to be hospitalized at that point. And I would also say that most of the counties, if you're anything like our county, started getting tons of people with Alzheimer's and dementia. And these individuals on 102 commitments, the first prong must be that they have a mental illness. And dementia is not restorable. And so those people are not appropriate for this. You are honestly left in limbo by the code as to what to do with those individuals, because they do not meet criteria for the civil commitment, but they cannot be prosecuted. Their case is stayed because they remain incompetent and will remain incompetent.
And it's also not appropriate if they have intellectual disability as their primary diagnosis.
Intellectual disability falls under 46B 103, slightly different process.
Yeah. Okay, we are going to move on to court-ordered medication. So you can tell today that, in an hour, hour and a half, we are not going to be able to go over every procedure in detail, but I want to let you know that these procedures are outlined in our bench book. They are in Professor Shannon's book. At the end of the slideshow, we have photos of these. And then we also mentioned that competency restoration guide that HHSC developed. And our bench book is available online. I like that version too, because you can search, do the Control F and search the whole thing and find, every single time something is mentioned to make sure you're covering it. Okay, well, a big possibility for a lot of counties is starting court-ordered medications. We know that it is not particularly appealing to some counties, and that is a hurdle to get over. We want to outline the process, and we want to connect you with other counties that have started it just to see how it goes. Some of the counties will start with just one person and just see how that goes. And I think that you see the results can be really very impactful, and that then you might want to start this process. But we recognize that it is taking away someone's liberty to force them into medication, and it's not taken lightly. But what we've also heard is that sometimes you just start to go through the process or even talk to the defendant that you're going to go get court-ordered medication, and then they will voluntarily take it. So I've heard that a lot.
On this, the last year I was in Collin County, year before last, we had something like 22 people who regained prior to transport. And so I have to balance the forced medication with a couple things. And one, somebody said to me, you just want to force medicate so you can convict them all. Well, no, I'm a defense attorney, but I can't get the case resolved and my person acquitted or any resolution until they're competent. So I'm doing them a disservice. But additionally, when you look at our wait list and you say that somebody on certain offenses are going to wait 2 years for a state hospital bed, and they have the potential to be restored in 2 months with the medication, that seems like an appropriate course of action, because I can then work with my client on what they want to do, because I can't envision that letting them deteriorate in their cell for 2 years is an appropriate course of action. But not only that, when you calculate, and hypothetically, let's say it's $100 a day for somebody to be housed in jail with mental health issues, it's actually quite more than that. But if you figure 365 days, what is that? $36,000 a year times 2 years versus only being in 2 months before you can proceed with the case. That's a huge cost savings for your county. And the cost savings is far more, because you also are not doing your one-on-ones and medications, and you also don't have the suicide risks and things that can really come with all of this. And so when I look at the grand scheme of it, also the other factor is the majority of these individuals, the moment they get to the state hospital's gonna file for an order. So the order's coming regardless of what point we do it, except that if we wait for the state hospital to do it, then we also waste 3 weeks of their hospitalization time waiting on that, when they could, if they get transferred and they have a med order, just step right into it without any lost time. So there's a number of important factors related to why we would do this.
I've heard that so much, that even if they are going to still go ahead to state hospital, that it shortens the stay by so much if they come in a better state, and they're not, like you said, wasting time there just trying to stabilize. So, okay, well, from the jail perspective, it is a Texas two-step. The criminal courts have to go to the court with jurisdiction.
Just along those lines, I think if we look at the fears and what people worry about, and as you said, this is a very convoluted process. But the reality is, you rarely ever go to the second step. The majority of the time, it's going to be resolved at the first step. So it does not end up being as complex as we fear. Our fears kind of get waylaid. I often hear the jails also say, well, what if we go to do the injections and a needle gets broke, or what if they fight us, or what if, I have just not found that to be something that happens. In fact, I can't even remember but one case in which somebody had to actually force it. The people when they were told the court ordered it, acquiesced to it, or they were somebody who was going to get an emergency med anyway and were restrained. But all these fears haven't come to fruition.
Oh, that's so good to hear, because there is a lot of fear around this. And if it can be helpful, that if your sheriff might be interested in this, or whoever, at your jail medical, and we could connect them to another county that's doing this to answer some of those questions of what it is actually like day to day, then we're really happy to do that. And I know HHSC is also doing a jail in-reach program where they're doing similar types of things. So let us know if we can help. So we want to make sure that when you're looking through the process, that you have some of these slides that will walk through the process for you. And so when we talked about civil commitment in our second class, we talked about medication there, just to kind of lay the foundation. And then we have this other category under 46B, and those are all the different circumstances when you can seek that court-ordered medication. Something else that we pointed out when we talked about the medication before is that we just changed the law to include that if you get the order for court-ordered medication, that now includes blood draws to monitor the patient and make sure that they're doing well, and all the medically recommended things that you need to do to make sure it's working and that their body is working well with the medication. That used to have to be another court order, and now that's been changed. So Alicia, did you have anything to say on this?
So the great thing about this is, normally when somebody would apply for court-ordered medication, they would have to first submit an application seeking mental health treatment, and then the application for court-ordered meds. But if a person has a 46B commitment, that is considered the application. So the only thing that then has to follow is the doctor's application for medication. And if anybody needs an example of that order, our doctor at Collin came up with a great form to fill that in quickly and submit it to the judge. And then I would just encourage you to sit down with your judge that handles this, whether it's the probate court or your county court at law sitting as probate, and determine what the process is. Because what we identified is the judge would come in on Tuesdays for his hearings. So that meant he needed these applications by such and such date and this time to set them. And our judge did not want the doctor who was the treating doctor testifying, because he felt like it broke down the rapport between the doctor and the patient. So he used a contract doctor who would review the content of the application and the files and then testify for these proceedings to preserve that rapport between doctor and patient. And that worked fine for us. And then he did the proceedings remotely from the jail. We coordinated it that way by Zoom or whatever means. And it worked quite efficiently once everybody decided how it was going to work.
Thank you. I see some questions in the chat. What counties are doing this successfully? And we see Collin and Travis. And I know there are some smaller counties that are doing it. Grayson and Denton, I think, have just started this process. So if you would like to talk to a county that is, more equivalent to your size and resources, I do think we're having success in other places as well. And throw that in the chat if you know of any other counties that are moving into this area. So we have a comment that another benefit can be a reduction in the likelihood of picking up additional charges while waiting to transfer, particularly picking up a new charge that requires MSU.
Absolutely. That's a great point.
Yeah, that is something so unfortunate that we see, is that someone who is even asking for mental health help can pick up charges, as we know, in the transfer, because it's scary, especially when you're having delusions. Okay, and another question is, what about EKGs with the court order? I do not know the answer to that. We just passed this bill in the last session. So I don't know, maybe the JCMH staff attorneys can pull up that language and see if we think it's broad enough for that.
And it may be, I mean, my inclination would be that an EKG is non-invasive and wouldn't necessarily require a court order, but I think that would have to fall to one of the medical experts to answer that one for sure.
That's a great defense attorney argument there. I like it. Yeah, it's maybe it's not invasive. I don't know. Maybe it is if you have to hold them down. Yeah, I'd be interested in seeing. Okay, so the next slide, we have some more of these great charts that lay out, this is the civil court medication process to, again, lay that groundwork. And then KMO's created this one that has the forms that go with each step. We have a form bank on the JCMH website that judges sat down and reviewed and made sure that it was up to par. And then maybe we can get a hold of the form that Elise was talking about from Collin County. I'm not sure if that's in our form bank or not, but we wanted you to have this chart so that when you are really starting to dig into the weeds and wanting to look at it step by step, then you have this. Okay, oh, it's an action one where I keep pushing. Yeah, then you go through the end of the steps. Okay, and so here we have a slide showing the different criteria for the court-ordered medication hearing. And they're both clear and convincing evidence, but the standards are slightly different, so just something to note. Another important point is that after restoration, that medication order remains in effect for 180 days following the defendant's return to court to await the criminal proceedings. Elise, how does this work practically?
And that one is so important for a couple of reasons. When I started at Collin, our medical provider at the jail refused to give the court-ordered meds regardless of the court's order. And so one of the things we did was we included that requirement in medical contracts to make sure that they would comply with court orders. But practically speaking, this is terrific because this is what prevents the deterioration of people and the return to the hospital. And I can tell you, in 10 years' time, we only had one person deteriorate and go back. And that wasn't related to failure to comply with this. I want to say that guy did not have a compelled order, was the reason. But it's just so important this is where the communication comes in with the court. So weekly, when we're having the medical meeting, I'm emailing the court, the defense and the prosecution going, FYI, this med order expires on this day and we expect there would be deterioration, 4 weeks later, FYI, just a reminder, we're starting to see, some concern to keep those cases moving. And it's just a matter of keeping everybody up to speed and working these cases while they're gone. That's just critical. But many counties were unaware. And in fact, in our county, this clause was missing from the court orders. And we were able to work with the judge to get those put on there after he reviewed the law, and that was in there. It just had never been used. So they left it out. And so when we recognized how useful that was and important, we put that on. And so it's also being sure that your medical people are complying with those meds that people come back on. While we cannot tell a doctor what to prescribe, we have implemented things when necessary. For example, we had a doctor at one point who was changing meds all the time. So the court put a standing order in place that if meds were changed on people returning from competency, we needed a court hearing to discuss it. It didn't prevent the doctor from doing it, but it made sure the court was aware and why it was happening. And of course, that never happened and we didn't have to utilize it. But there are things we can do to ensure, but it is critical they're complying with the meds they were turned on. There are sometimes I've seen our doctors have to tweak it just a little bit. And this is where that new legislation came into play with the blood work, because a lot of people are coming back from the state hospital. I think the medication is clozapam, but I'm not 100% sure, which requires blood testing weekly. And so that was a hard balance. And that's why they needed that legislative change. So it's just really critical to make sure everybody's staying on top of that when they come back, and that those orders are coming back with them and everybody knows the date.
Okay, so going back to the question about the EKGs, our staff attorneys have looked it up. That the statute reads psychoactive medication and procedures related to the medications. So if the EKG is related to the medication, that would be included. If it's not, then I would say it's probably not.
And I see, Christy, a couple of other questions in the chat. The date that 180 days starts. Yes, it is the date the court makes the finding. And then the typical timeframes for the court to see the client upon return. Yes, there are, but it's based on county size. But generally within 5 days of return, you'd have to look at it specifically based on your county size, though, because they are shorter for larger counties.
Okay, and that is when they have to make the finding.
Yes, ma'am.
Okay, we can look that up. Okay, well, we are at the end of our slideshow. We have another slide just pointing out that the obvious that these statutes are complicated, and that a lot of prosecutors, judges, defense attorneys are not familiar with them, and especially the details. So we want to highlight the resources. The book on the left is written by Professor Shannon. It's sponsored by NAMI, and I think the Bar Foundation helps print that for free. And then our bench book is free. It's online, and we still have some. We'll mail it to you if you ask. And the Texas Competency Restoration Guide, they dropped the link for it in the chat. And I know sometimes when I'm stressed, I don't want to go look it up in a book. I think if reaching out to someone that is in our network would be more helpful, then we can certainly do that. I want to say you have like the foremost expert on all these procedures on this call today. So if there are any other questions, this is the time.
So there's also a few other resources, Christy, and I think HHS Jail Forensic Team Jail InReach has a couple of those, such as templates to use when you're starting a jail medical meeting of what questions to ask so that you can move through it quickly. Because most of the problem when you're meeting on your mental health cases in jail medical is that people tend to look at it as an informational meeting. We all just want to know where we're at. And you have to look at it as who needs to do what. So we have this case, but we can't do a competency because there isn't a case filed. Okay, prosecutor, what can you do about setting it for grand jury? We need to resolve who needs to do what to move the case at those meetings. And that is the most important factor. in monitoring those cases and processing them.
Okay, well, we will definitely add that. Templates, I've seen those, you're right, from the jail in-reach program, and even some tips on how to get those conversations started. Has there been any targeted education for magistrate judges?
So 1623, not a lot with the magistrate judges, because I think the one you're referencing, 1623, is that the officer shall divert. And that is more directed to the officers. So I would say no, there's not a lot of magistrate training on that one.
Okay, the reason I was bringing it up is at one point I had been working as a clinician in a jail, and yes, it is the officer shall divert, but how we were sometimes leveraging that with the magistrate judges is helping to support them in rejecting the charges if there's an appropriate diversion option. And so I just, some of them were like very familiar with it, and some had no idea what we'd be talking about, which is understandable. There was a large county with many magistrate judges filling, a lot of extra time, but it seemed some of them were very willing to go that route when there was appropriate planning, brought in with the LMHA and stuff. So I was just curious how
That's a
comfortable
great
they
point.
felt.
And I think Colin primarily leveraged that at the jail book-in window by kind of coming back on the officer if it was very clear it was an APAL or a apprehension for a mental health evaluation or something of that nature. But some of the other stuff was just so discretionary that there wasn't a lot of conversation about that.
I think it's a great point, though. Even looking back in some of our summit conversations, we have Chief Stan Standridge talking about how the best way to work on competency restoration is to stop so many people coming through the front door. And that law enforcement are very educated about probable cause and other things, but not so much about diversion. And so it really is an important point to bring in all those pieces together in diversion.
Christy, and you have a question here from somebody: suggested response to defense attorneys who don't understand this and say that it's not their role to advocate for a client to be locked up or committed any longer than needed. We do run into that a lot. And we even run into it a lot with defense attorneys who say, I'm not a social worker, this isn't my job. But as we're moving towards a holistic defense and looking at, you can't view, your average person who's not suffering mental health issues, who gets a criminal trespass, understands, and yes, 5 days in jail may solve the issue. But when you have a person who's suffering with mental health issues, there is obviously a lot of ethical concerns from defense attorneys. Well, if I suggest incompetency, they can spend far more time in jail than if I just plead it. You do face those concerns, but you're required to bring that up. And I think the discussion then has to lie more on what the alternatives are in the community, because I wouldn't say that I ever advocate for a client to be locked up or committed any longer than needed. I'm wanting to move the case, and I'm going to suggest every way possible to prevent that being locked up longer than needed by offering suggestions and alternatives. But I don't think ethically I can get around suggesting incompetency if it exists. I might try to work with my client on their education and understanding, because it's very common to hear the term, well, they're competent enough for a Class B. And what they mean by that is it's a lot harder to explain to somebody felony charges and enhancements than it is to pleading to a Class B misdemeanor. And so I think we have room to work on that. And I just don't view it that way. If an attorney views it that way, as advocating for their client to be locked up or committed, I would have a concern about their ability to serve on that case. And it goes further to demonstrate that having attorneys who are educated in mental health serves the client better in the long run.
It's always difficult to weigh the your ethical duties and the counselor role for what's best for your client. You have to be smart about it.
And for attorneys on here, there's an excellent article. It's pretty old in Texas Criminal Defense Lawyers, but you can search it, and it was called Catch 22. And that's essentially what it was about: is my client can go in and plead to 5 days and be out today, or I can suggest incompetency and they're going to be here 180. How do I balance that with my ethics? And a fabulous article on it. And And that certainly is the problem, because I found that many of the prosecutors, well, we'll let them out in 180 days. Okay, but you're letting the person out in the same exact mental state that they were booked in, if not worse. But if you let them out now, we have an option of maybe diverting them somewhere. And earlier, one of the things Christy brought up as a problem is on a misdemeanor, if we aren't seeking competency restoration and our desire is that person get treatment, then what do we do? And a lot of times, well, and I think most of the time, we have to be super creative. We have to think outside the box. And maybe that is the prosecutor saying, okay, if your person will go to the mental health authority for 6 months and take services, I'll drop the charges. If your person will do A, B, and C, then we'll drop the charges. That works effectively for some people. Some people are so ill, excuse me, that they've got to be hospitalized first. So very often we would try to put those things in order, such as the jail's going to release them straight to the hospital. If the hospital accepts them, then they're going to enter services at the mental health authority. If the hospital refuses to accept them, then they're going to notify so-and-so to pick them up and transport them to the mental health authority to receive the intake. We just have to be really creative, because we all recognize that there is the black robe effect, and sometimes you need the court backing or the fear of the prosecution backing it. But that's where your mental health bonds with restrictions can come into play under 1622 and 17032. So, you can get really creative on the misdemeanors by using those statutes.
Well, thank you, Elise. This has been extraordinary to be able to just ask any questions and hear your practical experience. I want to encourage everyone to take this back to your counties and focus on it. We know that the wait list is one of the biggest problems in the state, and I know that the state hospitals are very much working on workforce and bringing new beds online. And so we want to make sure that our side of the house is ready, that if they can start moving through that wait list more quickly, are we ready to respond? And are we, again, not serving as a barrier? Are we part of the solution and not a part of the problem?
And I fully believe if every county would implement the compelled meds and the communication with a point of contact, we would save enough bed days that we would all see a drastic reduction in wait times.
This is a legal medical question. So let's say that we sent a patient from jail. It was started on a court-ordered med app in jail, went to an inpatient facility, received treatment, and while they were there, they did not enforce the court order. And so the patient was restored. They came back to jail, but were coming back into jail. They now are refusing certain meds. Is it ethical to keep the old med app in place, or would you need to go for a new med app? How would that work?
That med app is still in play, because there's nothing in the code that discharges that just because somebody doesn't enforce it.
Even if the hospital had felt like that they no longer met criteria for it? I mean, I guess that's my thought process.
Well, that's so part of not meeting, part of the med app and the continuation of it when they return to jail is, we know they would stop taking it if they could, if they had the choice, which is why it's in place. So that makes sense. And the hospital not enforcing it, meaning the person then begins voluntarily taking, still provides that med app's in play if that person chooses not to take it. So I don't think that changes the role of giving you the power you need to compel that med if you have to during that 180 days.
And Elise, do you ever have to try to extend it beyond the 180?
Unfortunately, yes, with some of the higher level charges, first degrees murders, very frequently you could have to do that. And that is problematic, because if you're not paying attention to the dates, you can have to wait till that person deteriorates to a point again where you can enforce it. And you really don't want that to happen.
So for the procedure of that, I would just file. So we're looking at 160 days, and it's coming up, but I still don't feel that the patient has the capacity to make decisions about medication. So I would just file a new app because there's not an extension. We did file for a new one.
And that's
on-
what we did. And I think you also have to remember, if the court comes back and refuses it, that's when you have that second prong to go to the criminal side. And the criminal approval of that is based on the state's the interest in justice. So if your probate judge says, well, no, they're taking the meds, they no longer meet criteria, then the state, especially on a case like murder or something of a greater offense level, the state would then file with the criminal court within 10 days of that refusal to have it heard. And then the criminal court it's in the interest of justice, not necessarily just the criteria you just went through in the probate court. So you're more likely to get that. So you do have the two choices, and obviously they have an interest in justice on a murder charge. So you would continue to get those.
Okay, well, we will give you all 10 minutes back in your day, and we appreciate your participation. Again, we'll be making a video out of this. There will be CLE attached. Thank you all.